It's June 2024 and I'm back at the Mystery Town. The purpose is to hear all the cases that are dealt with at this court and discuss deterrence. There are 12 defendants on the list on this slightly chilly winter's day. However, only 3 were finalised, so there will be 3 parts. By the way, I'm at Wentworth Local Court. In case you question my commitment on going regional, Wentworth Local Court is about as far away from the local courts in the Hunter Valley as you can get in New South Wales. Wentworth is where the Darling River meets the Murray River. You can see Victoria from here. Wentworth is part of the Broken Hill circuit. So court sits here usually 1 week a month, Wilcannia for a couple of days, and the rest of the time they're in Broken Hill. The first case is Cheryl, not her real name. It's an AVO, an apprehended violence order. I don't normally disclose the gender of the parties in the AVO cases. However, I will this time just to show you that all the genders can be subject to AVO applications, not just males. So police are seeking the court to make an order to protect a man from Cheryl. It is common to see other charges associated with AVO cases like assault or intimidation. However, Cheryl has no other charges, just the AVO. Cheryl is opposing the AVO. Both the police and Cheryl have submitted evidence to the court. As either party has declined to cross-examine the evidence, for example the witnesses, this AVO application will be dealt with on paper, meaning the magistrate will read everything and then make a decision. However, on this day, Cheryl's solicitor was under the understanding that witnesses would be cross-examined. But the magistrate is firm. No, both parties were asked this at the last court mention and declined. The case is stood down so the solicitor can have a discussion with Cheryl. They return and they accept that it will be dealt with on paper. Then both the defence and the prosecution start making objections to the material that's been submitted to the court. The magistrate, the defence and the prosecution all identify, discuss and delete parts of the evidence. They are talking in paragraphs and this sentence and that sentence. Basically, they remove things like opinions. For example, one witness claimed a person had a mental illness. A person needs to be qualified to claim that. You can't just say someone is crazy and it be accepted as fact. This goes on for a long time. AVOs are made under the Crimes, Domestic and Personal Violence Act 2007. Under Section 16, a court may make an AVO if it is satisfied on the balance of probabilities that a person who has or had a domestic relationship with the other person has reasonable grounds to fear or in fact fears violence, intimidation or stalking. So what the magistrate is going to test is the reasonable grounds. This isn't explained beforehand, however I find the explanation given by this magistrate as we go along to be clear, which I think helps us in the gallery. It's agreed Cheryl and the man in need of protection were in a relationship in 2023. It ended in December where things soured. The man had messaged Cheryl to end contact, however Cheryl did go around to his residence where they agree things got out of hand. The defence solicitor states the relationship had its ups and downs and argues this doesn't warrant the court's intervention. The solicitor explains that while Cheryl wasn't welcome at the man's home, she went around not for sinister reasons, only to collect her belongings. However, some photos of the couple got smashed. The solicitor repeatedly uses "not sinister." Again, the solicitor explains Cheryl only emailed the man after being told not to contact him because she wanted to dispel the rumour that she had told people where the keys to the gun safe were. Cheryl claims she told no one where the gun safe keys were kept. By the way, the magistrate has pages and pages of texts and emails. The pages aren't numbered, which causes everyone grief. In my opinion, arguing that it's not sinister goes to persuading the magistrate that Cheryl wasn't doing these actions with a criminal mind. It's noted that it's been 6 months since the last contact. Even in this small town where Cheryl works in a Main Street business, the two have not crossed paths. In the end, the magistrate decides that while the allegations against Cheryl are broad and non-specific, they do satisfy that there are grounds to fear. However, they are not significant enough to make an order. The magistrate declines to make the order and Cheryl walks away from court. As you can see, it's an issue between two people. So is there any point in talking about a case like this outside court? For me, I still want to hear about the case. Not about who said what and which photos of the couple got smashed or where the keys to the gun safe are. Rather, I find it interesting to know how the court dealt with the matter. Did the court follow the law? I feel like there are so many cases in the New South Wales Local Court that are interesting examples of how the court is handling itself, but they are never spoken about. That's all from Wentworth. Stay tuned for the second part.